Section D Attachment. Count 1, Actions of Defendant Chad Gray, First Fault. Plaintiff incorporates all factual statements, stated below. 1. Beginning in or about 2020. And continuing thereafter. Defendant Chad Gray contacted and pressured plaintiff's landlords in an effort to remove plaintiff from housing. And his conduct formed part of a continuing course of harassment and destabilization against plaintiff that has persisted to date. A. Plaintiff's residence at or about 2020 North College Avenue, Fort Collins, Colorado, where plaintiff was abruptly required to leave. B. After relocating, plaintiff's residence at or about Willix Lane, where plaintiff was again forced to leave following Gray's continued interference. And C. Plaintiff's later residence at or about 12908 Palomino Place, Wellington, Colorado, where Gray again attempted interference but the landlord refused to displace plaintiff. As a result of Gray's housing interference, plaintiff's ability to maintain stable housing was disrupted, and plaintiff's right to continue residing at housing plaintiff was legally entitled to occupy was repeatedly undermined. 2. In early 2022, defendant Chad Gray initiated interference with plaintiff's housing by contacting the landlord of the shared residence and asserting complaints designed to have plaintiff removed. Gray represented to the landlord that plaintiff should no longer be permitted to remain in the home, even though plaintiff had violated no lease terms and no lawful basis for removal existed. 3. As a direct result of Gray's communications, the landlord abruptly informed plaintiff that he had to leave the residence. Plaintiff was not served with any written notice, was not given an opportunity to discuss or dispute the claims made by Gray, and was not afforded any of the procedural protections required before terminating a lawful tenancy. 4. Following Gray's interference, plaintiff was effectively excluded from the property and prevented from continuing to reside there. Plaintiff lost access to personal belongings and suffered immediate displacement. This amounted to a constructive eviction carried out without due process, depriving plaintiff of property interests and residential stability in violation of the 14th Amendment. 5. After plaintiff was told to leave, the landlord, acting under the influence of defendant Gray's complaints, refused to allow plaintiff to return to the residence to continue living there. Although no lawful eviction process had occurred, the landlord made clear that plaintiff was no longer permitted on the premises. Because law enforcement had historically accepted and acted on Gray's statements in prior unrelated interactions, plaintiff reasonably feared that returning to the residence without the landlord's permission would result in confrontation or police involvement. This effectively prevented plaintiff from accessing a home he was legally entitled to occupy, causing forced displacement and substantial loss. 6. Plaintiff was not provided any formal eviction process, paperwork, or hearing in connection with the removals described above and was forced into sudden displacement. Plaintiff was unable to collect all belongings, suffered damage to personal items, lost work due to the forced relocation, incurred financial strain from emergency relocation, and suffered emotional distress associated with the abrupt loss of housing stability and personal security. 7. At all relevant times, Chad Gray acted under color of law by using and leveraging his position as a code enforcement official, and the apparent authority of that office, to pressure plaintiff's landlords and threaten adverse governmental action, including threatening to obtain a warrant to have plaintiff's bus removed during the Willix Lane period. 8. Plaintiff alleges that Gray's housing interference overlapped in time with the onset of harassment by defendants Thayer and Archbell, and, on information and belief, based on later public statements and admissions by Thayer regarding an ongoing relationship with defendant Arod, these actions were part of a broader, connected course of conduct described elsewhere in this complaint. Count 2, Actions of defendants David Archbell and Robert Thayer. Plaintiff incorporates all factual statements, stated below. 9. After plaintiff sought legal relief regarding the unlawful removal from his residence, defendants David Archbell and Robert Thayer initiated a sustained pattern of confrontation, intimidation, and targeted harassment directed at plaintiff. As documented in Affidavit 2, both men confronted plaintiff in a shopping center parking lot while visibly armed. They approached plaintiff in a hostile manner, engaged him verbally, recorded the encounter, and later published the video online accompanied by false and misleading statements portraying plaintiff as dangerous or unstable. 10. The videos posted by defendants over the last 3-year time span drew negative public attention and resulted in hostile reactions from viewers who accepted defendants' false statements as true. Plaintiff experienced fear for his safety due to indirect threats and comments arising from the video's circulation. Plaintiff promptly reported the incident to law enforcement and provided officers with the video as direct evidence of the confrontation. Despite the presence of armed individuals, online publication of defamatory content, and plaintiff's detailed report, authorities did not investigate or provide any protective response. 11. Shortly after the first incident, defendant Archbell again confronted plaintiff while visibly armed, this time inside a King Soopers grocery store, as documented in Affidavit 3. Archbell followed plaintiff through the store, recorded plaintiff at close range, and attempted to provoke a reaction. He later posted the footage online with commentary designed to mischaracterize plaintiff's behavior and further harm plaintiff's reputation. These actions occurred in the presence of customers and store employees. Plaintiff formally reported this second armed encounter to law enforcement, yet no investigation or protective measures were taken. 12. From 2022 through 2025, defendants Archbell and Thayer continued to engage in repeated acts of monitoring and harassment. they appeared at public locations where plaintiff was present, followed plaintiff during routine activities, and posted images and statements about plaintiff online. Their conduct created continuous fear, humiliation, and instability. As a result of defendant's persistent actions, plaintiff was forced to alter routines, limit public activity, and remain in a heightened state of vigilance due to the ongoing, unpredictable nature of their behavior. Arch Bell and Thayer repeatedly invoked or implied their association with law enforcement and acted with the knowledge that officers would not intervene, evidencing joint participation under color of law. Count 3. Actions and omissions of law enforcement, Larimer County and Fort Collins Police. Plaintiff incorporates all factual statements, stated below. 13. Throughout these events, plaintiff repeatedly reported incidents involving defendants Arch Bell and Thayer to both the Fort Collins Police Department and the Larimer County Sheriff's Office. Plaintiff provided specific dates, locations, descriptions of conduct, and, in several instances, direct video evidence documenting the confrontations, surveillance, and online postings. 14. Despite plaintiff providing officers with detailed information and, in some instances, offering video evidence of the confrontations, law enforcement did not conduct any meaningful investigation. Officers did not follow up with plaintiff, did not contact the individuals involved, and did not take steps to evaluate or address the ongoing pattern of harassment. In multiple reports, officers concluded the situations were civil or otherwise declined action without reviewing available evidence, leaving plaintiff without protection despite repeated requests for assistance. 15. This pattern of refusal by law enforcement to take action or to document plaintiff's reports enabled the continued conduct of defendants Arch Bell and Thayer. Their ongoing surveillance, repeated approaches, and continued recording of plaintiff occurred without any deterrence or consequence, increasing plaintiff's fear and leaving plaintiff without protective assistance from local authorities. 16. Law enforcement's repeated failure to respond, investigate, or document plaintiff's reports despite clear warnings that the conduct was escalating left plaintiff without protection and vulnerable to continuing harassment. As the incidents continued and intensified, plaintiff was left with no reliable means of securing safety and was compelled to relocate multiple times in an effort to avoid further contact with defendants Arch Bell and Thayer. 17. The demonstrated unwillingness of police to intervene, even after incidents involving weapons, threats, and repeated confrontations, caused plaintiff to experience increasing fear, anxiety, and hypervigilance. Plaintiff reasonably believed that calling law enforcement would not result in assistance and might expose plaintiff to additional risk, further compounding the emotional harm and instability caused by the ongoing harassment. These repeated failures reflect a broader policy or custom of disregarding credible citizen reports of harassment and retaliation, rendering both agencies liable under Monell. 18. Plaintiff promptly reported the incident to local law enforcement and provided officers with the original video evidence and a detailed account of the confrontation. Despite the armed nature of the incident and the documented online escalation, authorities declined to take action, did not open an investigation, and failed to offer any protective measures, further emboldening the defendants. 19. Plaintiff formally reported this second armed encounter to law enforcement, yet no investigation or protective measures were taken. 20. Plaintiff made repeated reports to Fort Collins Police and Larimer County authorities regarding the confrontations, surveillance, and online activity. Despite providing dates, descriptions, and in some cases video evidence, officials took no action, offered no protection, and did not intervene to stop the ongoing conduct. 21. The failure of authorities to act allowed the harassment to continue unchecked, contributing to plaintiff's emotional distress, loss of stability, and deterioration of physical and mental health. The lack of intervention also emboldened defendants, who continued approaching and recording plaintiff even after official reports were made. 22. Despite the seriousness of the weapons incident and its direct relevance to plaintiff's earlier reports of armed aggression, law enforcement did not contact plaintiff, provide warnings, review prior complaints, or implement any protective measures. This lack of follow-up further demonstrated authorities' continuing failure to address credible threats against plaintiff. Count 4. Actions of Deputy County Attorney David Arod. Plaintiff incorporates all factual statements, stated below. 23. In 2025, after plaintiff filed for protective orders and other relief in Larimer County Court, Deputy County Attorney David Arod became involved in those matters even after discovering that he had been named in plaintiff's filings and affidavits. Despite this conflict of interest, Arod did not withdraw or recuse himself, and he continued participating in matters that directly affected plaintiff's ability to obtain court protection. 24. After becoming aware that he was identified in plaintiff's filings, Arod continued interacting with court clerks regarding plaintiff's paperwork. Following these interactions, clerks began refusing to answer plaintiff's routine questions, declined to provide standard procedural guidance, and demonstrated confusion about whether certain filings could be accepted. These changes in clerk conduct are reflected in plaintiff's affidavits documenting statements such as, "We can't discuss that," and "We were told not to." 25. As a result of Arod's continued involvement despite his conflict, plaintiff experienced irregular handling of filings, disruptions in communication with court staff, and uncertainty over whether filings were being processed at all. This interference hindered plaintiff's ability to pursue protective orders and obtain timely legal remedies, causing emotional distress and reinforcing plaintiff's fear that seeking judicial protection would trigger further retaliation or obstruction. These acts violated plaintiff's First Amendment right to petition the government and 14th Amendment right of access to the courts. 26 in 2025, after plaintiff submitted a notice of intent and sought protective orders and related relief in Larimer County Court, Deputy County Attorney David Arod became directly involved in matters affecting plaintiff's filings. At that time, Arod had already been identified within plaintiff's filings and affidavits as a named party and potential witness, creating a clear conflict of interest. Despite receiving notice of this conflict, Arod did not withdraw or recuse himself and instead continued to involve himself in the administrative handling of plaintiff's court matters. 27 After becoming aware that he had been identified in plaintiff's filings, Deputy County Attorney David Arod continued to involve himself in matters affecting plaintiff's ability to seek protection. Larimer County Administration confirmed to plaintiff that, at Arod's direction, that all of plaintiff's communications and inquiries were to be routed to him, even though he had already been named in plaintiff's filings and had a clear conflict of interest. This directive prevented plaintiff from communicating with neutral administrative personnel and forced all procedural questions, concerns, and notices through the very individual implicated in plaintiff's sworn statements, creating confusion, restricting access to proper channels, and obstructing plaintiff's ability to seek relief without interference. 28 Deputy County Attorney David Arod's continued involvement in plaintiff's matters, despite a clear conflict of interest, resulted in the breakdown of neutral and accessible remedy-related procedures. After directing Larimer County Administration to route plaintiff's communications through him, David Arod has caused delays, restricted plaintiff's ability to obtain information or assistance from neutral personnel, and contributed to procedural irregularities that obstructed plaintiff's efforts to seek redress. This interference materially impaired plaintiff's constitutional right to petition the government for relief and reasonably caused plaintiff to fear further retaliation or continued obstruction. Count 5 Court Access Interference/Procedural Obstruction, Deputy County Attorney David Arod. Plaintiff incorporates all factual statements, stated below. 29 Plaintiff sought legal protection through multiple filings in Larimer County courts between 2022 and 2025, including requests for protection orders, motions, and related pleadings intended to stop ongoing harassment and secure judicial intervention. 30 in 2025, after plaintiff filed for protective orders and other relief in Larimer County Court, Deputy County Attorney David Arod became involved in those matters even after discovering that he had been named in plaintiff's filings and affidavits. Despite this conflict of interest, Arod did not withdraw or recuse himself, and he continued participating in matters that directly affected plaintiff's ability to obtain court protection. 31 After becoming aware that he was identified in plaintiff's filings, Arod continued interacting with court clerks regarding plaintiff's paperwork. Following these interactions, clerks began refusing to answer plaintiff's routine questions, declined to provide standard procedural guidance, and demonstrated confusion about whether certain filings could be accepted. These changes in clerk conduct are reflected in plaintiff's affidavits documenting statements such as, "We can't discuss that," and "We were told not to." 32 Larimer County Administration confirmed to plaintiff that, at Arod's direction, all of plaintiff's communications and inquiries were to be routed to him, even though he had already been named in plaintiff's filings and had a clear conflict of interest. This directive prevented plaintiff from communicating with neutral administrative personnel and forced all procedural questions, concerns, and notices through the very individual implicated in plaintiff's sworn statements, creating confusion, restricting access to proper channels, and obstructing plaintiff's ability to seek relief without interference. 33 As a result of Arod's continued involvement despite his conflict, plaintiff experienced irregular handling of filings, disruptions in communication with court staff, and uncertainty over whether filings were being processed at all. Plaintiff experienced procedural irregularities and interference, including delayed communication from clerks, inconsistent acceptance of filings, and instances where filings were discouraged or not processed in the ordinary manner. 34 Plaintiff reasonably believed that continuing to pursue legal protection would result in further retaliation, particularly after the October 20, 2025 incident in which plaintiff received a criminal citation immediately following an attempt to lawfully serve defendant Thayer with court documents. 35 As a result of these experiences, plaintiff hesitated to file documents, make inquiries, or pursue certain forms of relief due to fear of further retaliation or punitive actions by officials. This interference materially limited plaintiff's ability to obtain timely and effective judicial protection. 36 Plaintiff's access to the courts was substantially impaired, and plaintiff suffered continued emotional distress, uncertainty, and instability due to the obstruction of legal process and the reasonable fear that attempts to assert legal rights would provoke additional retaliation. These interferences caused actual injury by delaying plaintiff's attempts to secure protection orders and exposing plaintiff to continued danger during the period of obstruction. 37 These acts violated plaintiff's First Amendment right to petition the government and 14th Amendment right of access to the courts. Count 6 Retaliatory Citation/Retaliatory Policing, October 20, 2025. Plaintiff incorporates all factual statements, stated below. 38 On October 20, 2025, after a court hearing where defendant Thayer was present, plaintiff attempted to lawfully serve Thayer with process outside the courthouse. 39 On October 20, 2025, plaintiff appeared for a court hearing initiated by defendant Thayer through a motion for reconsideration that he himself had filed. Although Thayer did not attend the hearing, an unidentified woman associated with him appeared in the court, then waited in the truck in the parking lot with Robert till the plaintiff emerged. After the hearing concluded, plaintiff was required to give notice again, creating a period where no protection or monitoring was in place despite plaintiff's ongoing safety concerns documented in prior affidavits. 40 When plaintiff exited the courthouse, defendant Thayer was waiting in the courthouse parking lot. Thayer had positioned himself there in advance and initiated contact by taunting plaintiff, gesturing toward him, and motioning for plaintiff to approach or follow him. These actions were consistent with the prior pattern of provocation and unsafe behavior described in earlier affidavits. 41 Plaintiff followed Thayer only for the purpose of completing lawful service of process stemming directly from the court proceeding Thayer had initiated. Plaintiff's conduct was limited to carrying out the procedural requirement of service and did not involve threats, aggression, or any conduct prohibited by law. 42 Because of prior confrontations involving Thayer and Archbell, plaintiff notified Fort Collins Police in advance and requested that officers witness or stand by during the service. Officers refused, stating they would not be involved. 43 Immediately after plaintiff attempted service, Fort Collins Police issued plaintiff a criminal harassment citation. The citation was based entirely on plaintiff's attempt to perform lawful service of process, an action permitted under Colorado law and expressly allowed outside a courthouse. 44 The citation was issued without probable cause and without any meaningful inquiry into the circumstances. Officers did not review the documents being served, did not interview plaintiff, and did not assess the legality of service before issuing the citation. The timing of the citation directly following plaintiff's protected court activity demonstrates that the action was retaliatory. 45 Fort Collins Police converted the lawful service into a criminal harassment citation, characterizing plaintiff's required service activity as following Thayer. The citation was issued without investigation, without reviewing the court context, and without acknowledging that plaintiff's actions were part of a legally mandated process. This criminalization of lawful procedure had the effect, and apparent purpose, of retaliating against plaintiff for exercising court access rights and pursuing legal remedies. 46 The retaliatory citation caused plaintiff significant emotional distress, renewed fear of further retaliation, and hesitation in continuing court proceedings. Plaintiff experienced disruption of ongoing legal matters and increased concern that any future attempt to enforce legal rights or pursue filings could result in similar punitive action by law enforcement. The citation lacked probable cause because service of process is a lawful act and cannot constitute harassment under Colorado law. Count 7 Damages/ongoing injury. Plaintiff incorporates all factual statements, stated below. 47 As a direct result of the actions of all defendants, plaintiff lost stable housing, was forced to relocate multiple times, and was unable to remain in any residence for long due to repeated harassment and surveillance. Plaintiff also lost personal property during the initial 2022 removal and experienced ongoing financial instability caused by displacement, emergency lodging costs, and disruption of daily living. 48 Plaintiff experienced severe emotional distress, including fear, humiliation, anxiety, hypervigilance, and chronic sleep disruption, directly resulting from the persistent harassment, surveillance, repeated confrontations, and the refusal of law enforcement agencies to provide protection or investigate plaintiff's reports. 49 The prolonged stress, fear, and instability caused by defendant's actions contributed to significant physical deterioration documented in plaintiff's medical records. The unrelenting stress, fear, and forced instability culminated in severe health deterioration. The prolonged stress, fear, and instability caused by the ongoing harassment and lack of protection resulted in significant deterioration of plaintiff's physical health. 50 In 2024, plaintiff underwent coronary bypass surgery. Treating physicians confirmed that prolonged psychological distress, ongoing instability in plaintiff's living conditions, and plaintiff's smoking history were contributing factors to the cardiac condition. 51 Plaintiff's recovery was impeded by continued harassment, lack of safe housing, and ongoing uncertainty about personal safety. Plaintiff's medical recovery was negatively affected by continued harassment, interruptions in safe housing, and ongoing fear for personal safety. Plaintiff's ability to rest, adhere to medical recommendations, and maintain continuity of follow-up care was disrupted by the instability caused by defendant's actions. 52 Plaintiff experienced substantial financial losses as a direct result of defendant's conduct, including repeated forced relocations, costs associated with replacing property lost during the 2022 displacement, and the inability to maintain consistent employment while being subjected to surveillance, unwanted contact, and recurring harassment. 53 Plaintiff's ability to access the courts was materially interfered with by intimidation arising from repeated confrontations by Archbell and Thayer. The retaliatory citation issued by Fort Collins Police on October 20, 2025, and the actions of Deputy County Attorney Arad, whose continued involvement created uncertainty and obstruction in plaintiff's attempts to file protective orders. These combined actions caused plaintiff to reasonably fear additional retaliation and resulted in delays in filing documents or pursuing court relief. 54. These financial, emotional, and physical harms were reasonably foreseeable consequences of defendant's conduct. The repeated reports plaintiff made to law enforcement and county officials placed them on clear notice that the harassment, surveillance, confrontations, and disruptions to plaintiff's stability were escalating and causing measurable harm. Despite this notice, officials failed to intervene, prevent further incidents, or provide any form of protection, making the resulting injuries a predictable and avoidable outcome of their inaction. 55. These harms are ongoing. Plaintiff continues to experience fear for personal safety due to recurring harassment and lack of protection, as well as financial instability caused by repeated relocations and loss of property. Plaintiff's medical care and recovery have been disrupted by unstable living conditions, and plaintiff continues to encounter obstacles when seeking legal protection or attempting to engage with court processes. Count 8 Civil RICO, 18 U.S.C. 1962, c. Plaintiff incorporates all factual statements stated in counts 1 to 7 as if fully set forth herein. 56. Plaintiff alleges that defendants Chad Gray, Robert Thayer, David Archbell, and David Arod, together with other persons known and unknown, formed and/or associated with an enterprise within the meaning of 18 U.S.C. 1961, 4, including an association in fact enterprise, for the common purpose of harassing, intimidating, discrediting, obstructing legal relief, and destabilizing plaintiff's housing, safety, and ability to pursue lawful remedies. 57. The enterprise had relationships among the participants in a continuing structure and longevity sufficient to pursue its purpose, as shown by the repeated and coordinated course of conduct alleged across multiple years, including housing interference, repeated armed confrontations, online targeting and doxing activity, coordinated obstruction/interference in court access, and retaliatory policing following court-related activity in lawful service of process. 58. On information and belief, defendants conducted or participated, directly or indirectly, in the conduct of the enterprise's affairs within the meaning of 18 U.S.C. 1962, c, including by performing and coordinating actions that furthered the enterprise's purpose and by using apparent or claimed governmental authority to amplify the impact of the enterprise's actions. 59. Plaintiff further alleges that the enterprise engaged in, and its activities affected, interstate commerce through, among other things, the use of electronic communications and online publication and dissemination of content and claims directed at plaintiff and the public. 60. Plaintiff alleges a pattern of racketeering activity within the meaning of 18 U.S.C. 1961, 5, consisting of at least 2 acts of racketeering activity within 10 years that were related and amounted to, or posed a threat of, continued criminal activity, as shown by the repeated acts described in counts 1 to 7 and the continuity of conduct from at least 2020 through 2025 and thereafter. 61. The acts constituting the pattern include, on information and belief and as supported by the described videos, publications, reports, and official communications, conduct that plaintiff will further specify and prove through discovery, including racketeering predicate acts such as a 18 U.S.C. 1951, Hobbs Act, extortion and/or attempted extortion, including extortion under color of official right where applicable, through threats, fear, and/or misuse of apparent governmental authority to pressure third parties and impose adverse consequences on plaintiff. B. 18 U.S.C. 1512, b. Witness tampering and intimidation intended to hinder, delay, prevent, or dissuade plaintiff from pursuing, participating in, and communicating evidence in litigation and related official proceedings and processes, including reporting, filing, and service, of process activity. C. 18 U.S.C. 1513, e. Retaliation against a witness, victim, or informant for pursuing legal relief and participating in legal process, including harassment and intimidation linked by defendant Archbell, in recorded statements, to plaintiff's 2022 civil suit and related efforts to obtain judicial protection. D. 18 U.S.C. 1343 Wire fraud, based on the use of interstate electronic communications and online publication to disseminate materially false representations about plaintiff and defendant's claimed authority/status, in furtherance of a scheme involving monetization and/or solicitation/receipt of funds through electronic payment mechanisms. 62. Plaintiff alleges that defendant's conduct was not isolated or accidental but coordinated in timing and function, including role splitting, housing pressure, armed confrontation and online publication, administrative obstruction, retaliatory policing, and admissions suggesting that at least one participant acted with an expectation of monetary compensation and/or official backing through asserted county contracts, supporting the inference of an enterprise purpose and coordinated action. 63. As a direct and proximate result of defendant's violations of 18 U.S.C. 1962, c. Plaintiff suffered injury to business and property, including but not limited to, loss of and damage to personal property, out-of-pocket relocation, and emergency housing costs, lost work and lost income opportunities caused by repeated displacement and targeted harassment, and other quantifiable financial losses alleged in counts 1 to 7. 64. Plaintiff seeks relief available under 18 U.S.C. 1964, c. including treble damages, costs, and such other relief as the court deems proper. Count 9. Monell liability/policy, custom/failure to train, supervise, discipline, City of Fort Collins and Larimer County. Plaintiff incorporates all factual statements previously stated, including counts 1 to 8, as if fully set forth herein. 65 Defendant City of Fort Collins, Colorado is a municipal corporation organized under Colorado law, with principal offices at 300 LaPorte Avenue, Fort Collins, Colorado, 80521 and is liable under Monell for constitutional violations caused by official policies, customs, patterns, or failures to train, supervise, or discipline within Fort Collins Police Services. 66 Defendant Larimer County, Colorado is a political subdivision of the state of Colorado, with principal offices at 200 West Oak Street, Fort Collins, Colorado, 80521 and is liable under Monell for constitutional violations caused by official policies, customs, patterns, or failures to train, supervise, or discipline within county departments, including the Larimer County Sheriff's Office. 67 Defendant Chief Jeff Swoboda, Chief of Police for Fort Collins Police Services, is sued in his official capacity for prospective injunctive and declaratory relief addressing FCPS policies, practices, training, and supervision. FCPS Headquarters, 2221 South Timberline Road, Fort Collins, Colorado, 80525. 68 Defendant John J. Fayan, Larimer County Sheriff, is sued in his individual and official capacities. Sheriff's Office Administration, 2501 Midpoint Drive, Fort Collins, Colorado, 80525. 69 Defendant Janine S. Hogg, Larimer County Attorney, is sued in her official capacity to ensure prospective injunctive and declaratory relief reaches the County Attorney's Office where appropriate. Office Address, 224 Canyon Avenue Suite 200 Fort Collins, Colorado, 80521. 70. Plaintiff alleges that the constitutional injuries described in counts 1 to 7 were caused, enabled, prolonged, and/or ratified by the policies, customs, and practices of the City of Fort Collins and Larimer County, including a pattern and practice of a. Declining to investigate or meaningfully respond to credible reports of harassment, stalking-type conduct, intimidation, and retaliation. B. Misclassifying escalating conduct as civil without meaningful review of available evidence. C. Failing to accept, review, preserve, or act upon offered video evidence and witness information. And D. Permitting repeat non-enforcement responses that communicated to perpetrators that continued targeting would occur without consequence. 71. Plaintiff further alleges that the City of Fort Collins and Larimer County maintained inadequate training, supervision, and discipline of officers and personnel regarding a. Recognition and handling of repeated harassment and intimidation reports, b. Review and evaluation of video evidence, c. Documenting repeat incidents and patterns, and d. Preventing retaliatory enforcement actions following protected court-related activity, amounting to deliberate indifference to an obvious risk of constitutional injury. 72 As described in counts 2 to 3 and elsewhere, plaintiff repeatedly reported incidents involving defendants Archbell and Thayer to Fort Collins Police and the Larimer County Sheriff's Office, including providing dates, locations, descriptions of conduct, and, in multiple instances, direct video evidence documenting confrontations, surveillance, and online postings. Despite repeated notice and escalating risk, officials failed to conduct meaningful investigations or provide protective responses. 73 Plaintiff alleges that these municipal policies, customs, practices, and failures were the moving force behind the continued and escalating deprivation of plaintiff's rights, including the continuation of the harassment described in counts 2 to 3, the chilling and obstruction effects described in counts 5 to 6, and the damages described in count 7. 74. Plaintiff alleges that Chief Jeff Swoboda, in his official capacity, and Sheriff John J. Fayan, in his official capacity, and, where applicable, in his individual capacity, were responsible for the implementation, training, supervision, and oversight that resulted in the policies, customs, practices, and failures described above, and that prospective declaratory and injunctive relief is necessary to prevent continuation of unconstitutional practices within FCPS and the Larimer County Sheriff's Office. 75 Plaintiff further alleges that Janine S. Hogg, in her official capacity as Larimer County Attorney, is a proper official capacity defendant to ensure that prospective declaratory and injunctive relief reaches the County Attorney's Office where appropriate, including where County Attorney involvement, oversight, or directives contributed to or perpetuated the patterns of non-response, obstruction, or retaliation described in this complaint. 76 As a direct and proximate result of the City of Fort Collins and Larimer County's policies, customs, practices, and deliberate indifference described above, plaintiff suffered the injuries described in count 7, including loss of housing stability, out-of-pocket losses, loss/damage to property, emotional distress, fear, and continuing impairment of plaintiff's ability to obtain meaningful protection through ordinary channels.